Attorney Kip from Malek. So with a change of the new year, it's 2024, and with New Year's we always have New Year's resolutions. So I've come up with a top 10 list of things to do in relation to your workers' comp claim in 2024. So number one, this is before you get injured, but also tell everyone you know that who has gotten injured to do this. So this is the first thing. When you get injured, seek some type of treatment or evaluation of your work injury as soon as possible. If it's serious or life-threatening, obviously you're going to go to the ER. If it's less than serious or life-threatening, maybe save some money, go to urgent care, possibly your primary care physician, or if you have a BWC POR for a prior injury, maybe go back to them. But as soon as you can get your work injury documented and evaluated, it's, there's two things you want to get. Obviously you want to get treatment, but you also want to get documentation. So for the workers' comp claim, documentation is huge. The closer you get documentation of the work injury to the actual date and time of the work injury, the better. So that's number one. And also tell everybody that gets injured that fact. Tell them get treatment, get documentation as soon as possible. So the second thing, report your injury to HR, your supervisor, manager, coworker, everyone. You want to be as accurate as possible, as precise as possible, as complete as possible about when it happened, how it happened, what you were doing, what body parts you were injured. And the more accurate you can be, the more specific you can be, the better. The more precise you can be, the better. And also, obviously, when you go seek medical treatment, give them an accurate, complete, and specific summary of what happened as well. Because a common thing that we run into is injured worker tells their one provider one thing, and they tell another provider a slightly different thing, or at least it's documented slightly different. It always creates a question of credibility and versus did the medical provider document things wrong. So we want to avoid that. So that's number two. Number three. So here's the thing: if you get a work injury, you should obviously file a workers' comp claim. If it's an Ohio workers' comp claim, file an Ohio BWC claim. And obviously, if it's legitimately a work injury, you want to get the treatment and a comp through your workers' comp claim. Sometimes, for a variety of reasons, things take a while. You get the claim allowed, or to get a condition added that you need in order to get some more substantive treatment. For example, your claim's allowed for a left shoulder sprain, but in fact you get an MRI and it shows a rotator cuff tear, but it's got some degenerative things. The employer or the BWC are disputing whether that's a rotator cuff tear from the injury versus a pre-existing rotator cuff tear that has no relation to the work injury at all. So, and meanwhile you have this painful shoulder. So if you could pursue things with a workers' comp claim, do that, but also consider other paths to treatment and receipt of comp. For compensation, do you have short-term or long-term disability benefits through your employer? Is there some other kind of compensation that you could pursue? For treatment, if can you pursue that surgery in this example through your personal insurance? Some insurance providers will do surgery, and some medical providers will do the surgery even though they know it's a workers' comp claim, or it may be. Some don't, but you have to approach them with that question. Do you have veteran benefits? Can you pursue treatment through your veterans benefits, Medicaid, Medicare? But obviously you're going to try to get things through workers' comp, but if you can't, you really do need to consider other paths to getting these treatments and compensation. If you don't have those opportunities available to you, then you don't have those opportunities available to you, but definitely check it out. The other thing is, for your outstanding bills, if your claim's being denied and you think it's going to be denied, HCAP your bills. Call the financing department in the hospital and say, hey, I want to discuss HCAPing my bills. And obviously, if your claim's allowed, the claim would pay the bills, but if your claim's not allowed and it's denied or something, then you're going to get, you may get these bills and they may end up going to collections or something, so you might want to take care of them if that's something that concerns you. Communication. So number 4 is communication. So we'll get calls from injured workers represented by other law firms, and they'll be like, hey, my attorney never talks to me, et cetera, et cetera. So in the 2024, if you're one of those folks who have been spoken to by your attorney in a while, then go ahead and call up your workers' comp attorney and schedule an appointment. Any workers' comp attorney worth their salt will gladly schedule an appointment. They'll set aside time to speak to you, whether that's 20 minutes, 30 minutes, an hour, however much time that they could set aside, it's worth it. But call them up, set up that appointment, communicate to them, get a summary of what's going on with your claim, what's going to happen with your claim, what they think is going to happen, some issues that they think they're going to run into, concerns that you might have with your claim, etc. But have that point of communication. Don't feel bad about asking your workers' comp attorney, whoever that may be, hey dude or ma'am, I want an appointment. So they'll do that. Number 5, if you don't have a workers' comp attorney, consider the benefits of getting one involved. You may be one of those unicorns whose claim is going swimmingly along and is perfect, and that's awesome. I would hope that everybody has that same experience, but the reality is it's not the norm with a lot of these claims. Sometimes your claim is going along swimmingly and then you run into headwinds. Sometimes it benefits you to have spoken to an attorney earlier when things were going great, and to have your attorney involved earlier when things were going great. Because there's some things that you should have done back then, and now it's too late, or now you're running into problems because the foundation hasn't been set correctly. So when folks call and they have things are going well, I mean, I will, and that, maybe I'm the exception, but I doubt it. I think workers' comp attorneys for plaintiffs, as a rule, are an honest group of people and will tell you like it is, so to speak. But if I don't think somebody needs an attorney, or I don't think it's necessarily going to benefit them, I will tell them, hey, I think you're okay. I don't think you necessarily need an attorney right now. Just because you call an attorney and you give them, you ask them a question, you give them a rundown of your situation, doesn't mean you're obligated to sign up with somebody. So, and I myself, if I don't think somebody needs an attorney, I will tell them, yeah, I think you're okay. But on the other hand, even if you don't necessarily need an attorney, what's the worst that's going to happen? You're going to have an attorney in the background looking at things, making sure things are going smoothly. They're paid on a contingency fee basis. If you're already receiving comp and all these things, you're not going to have to. They're not necessarily, the contingency is not going to trigger, so you're not necessarily going to pay them. So you're going to have this essentially free person looking over your claim. So there's a benefit in that sense, even if things are going great. Number 6, set up an e-account on the BWC website. Set up an e-account on the Industrial Commission's website called ICON. It's better. It's really great to be informed. If you have a BWC e-account, you can see all the documents that are being placed there. You could see what's going on. Like if you're looking, I'm not sure if I have my Medco 14, if that's there, if the workers' comp has it or not, you can see. And it's free. It's easy to set up. I'll put a link to where you click to set that up, but it's super simple. It's going to benefit you. Set up an e-account. Number 7, have you checked your average weekly wage? Do you know what your average weekly wage is? If not, and again, that might be a reason why you set up an e-account, but if not, figure out what your average weekly wage is, particularly if you're receiving temporary total disability comp. Because if your average weekly wage is low, there may be that it was set low because the BWC didn't have all the wages when they calculated it, or there may be ways to raise it, like excluding weeks where you're unemployed. But if it's low, look into it. You might be able to raise it. So it definitely benefits you to check it out. So look at your AWW. If it seems low, it may very well may be low, and there may be a reason why it is, and there may be a way to raise it. So check it out. And also I've done a number of videos on the AWW and how to raise it and examples of how to raise it anyways. So watch those videos. Okay, number 8. So in the legal world, in the legal field, there's always a thing to consider, which is the statute of limitations, these time limits. So, you know, you have a year to do this, you have 2 years to do that, etc. There's time limits for everything. Workers' comp world, there's also time limits, and you have a year within which to file your workers' comp claim. So if you've suffered an injury and you haven't filed a claim, figure out precisely the precise date that you got injured. You have to file your claim in Ohio within a year before the anniversary date of that work injury. If you don't, unless there's some legal loophole available to get over that, then you may be SOL. You might be done. You might not be able to do anything. If you have medical bills from treatment you've gotten through your workers' comp claim, make sure you submit those bills within a year of the date of service of that treatment. So if you have on July 5th of 2023, you went to the ER related to your work injury, that ER bill must be submitted to the MCO or the risk management company within a year of the date of service. So it would need to be filed before July 5th of 2024. If you're considering filing what's called a violation of specific safety requirement, you have a year within which you can file that VSSR application. And there may be other things like that you typically don't file outside workers' comp, like intentional tort. Those have specific timelines that you have to file those as well. But figure out if any of these things you're kind of not sure. Don't wait on it. Don't sit on it. The worst thing you could do is wait until the week or a couple days before the deadline and then reach out to an attorney and say, hey, this thing happened and I don't know what's going on. I think I want to file. Most attorneys are going to be very, very reluctant to want to get involved at that point because the danger is the statute might be missed. You might have your date of injury wrong by a few days and you might be outside the statute already. So don't wait on that stuff. Pay attention to dates. Again, you have to file your claim within a year of the date of injury. You have to file your VSSR application within a year of the date of injury, and you have to file your medical bills within a year of the date of service of that medical treatment. Okay. This one, number 9, is kind of more relevant to people who are not represented because typically your workers' comp attorney will make sure that this happens. But have you filed a C-92 or what's called a permanent partial disability application? A lot of times a common thing that folks who are not represented, they might have multiple claims and some of their claims might have gone out of statute. And they may have very well, it might not have been a serious injury, but they did have some treatment and the claim was allowed for some conditions. You'd be entitled to what's called a C-92 or permanent partial disability application. So look into that. I've made other videos in the past about that, about C-92 application, what it is, how you calculate it, etc. But in general, you file it within 26 weeks from the date of entry or 26 weeks of last receipt of comp, whichever is later. So look into that. That's number 9. And number 10, if you haven't treated in a while and nothing's going on with your claim in a while and you're back to work and generally you're okay, consider can you settle your claim, because every claim has some kind of value. If you don't treat and nothing happens in your claim, at a certain point it will go out of statute and it'll essentially be done. It'll be dead. You can't do anything else with the claim. So if it's kind of done, think about trying to settle. Ask your attorney, hey, is it possible we could settle? Sometimes these claims are not settleable, or obviously if you're not treating, you're not getting any comp anymore, and you're generally doing okay. Obviously the settlement value is not going to be really great, but it's still beneficial to get some value out of your claim versus letting the claim completely die and essentially leaving money on the table that you could have received. And that's kind of the similar idea with the C-92 application as well. So those are the top 10 things to look into for 2024. And also in this year, I'm gonna be always, I post these videos, try to do 2 or 3 a month. If there's some particular area or something you want me to look into, or you have a particular fact pattern you'd like me to evaluate on one of these YouTube videos, I can certainly do that. Leave a comment in the comment section, or go ahead and email me directly. If you have a workers' comp claim and you want to run it by me, and you think you need representation, or at least you want to determine if you need it, go ahead and email me, or call my office. But as I say at the end of all these videos, the Ohio workers' comp system is incredibly complex and labyrinthine, and it just confusing for most folks, and most folks who aren't attorneys. So it behooves you to get an attorney involved, and it definitely is going to call a number of workers' comp attorneys, run by your situation, your fact pattern. If you need to get an attorney, determine which one you like best, you vibe with the most, get that person involved. If you need a referral, ask your coworkers, your friend, your relatives, ask your doctor, hey, I need a workers' comp attorney, do you have anybody you recommend? So, but definitely call somebody, run your situation by an attorney. It's going to benefit you. 99.9% of workers' comp attorneys will at least do like a free evaluation consult. At least we will. And then if you want to get us involved, that's fine as well. So, be that as it may, questions, concerns, comments, leave in the comment section, email me, call my office. Otherwise, please stay safe. It's a new year. It's winter. Be careful, and hope everything goes great with you this year. Thank you. Attorney Kip from Malek & Malek. Bye.